Under federal immigration law, certain criminal convictions can lead to deportation. These include convictions for crimes involving moral turpitude and aggravated felonies. Crimes of moral turpitude refers generally to conduct that shocks the public conscience as being inherently base, vile, or depraved, contrary to the rules of morality and the duties owed between man and man, either one's fellow man or society in general. Crimes against a person involve moral turpitude when the offense contains criminal intent or recklessness, or when the crime is defined as morally reprehensible by state statute. Criminal intent or recklessness may be inferred from the presence of unjustified violence or the use of a dangerous weapon. For instance, aggravated battery is usually, if not always, a crime involving moral turpitude. Simple assault and battery is not usually considered a crime involving moral turpitude. Moral turpitude attaches to any crime against property which involves fraud, whether it entails fraud against the government or against an individual. Certain crimes against property may require guilty knowledge or intent to permanently take property. Petty theft, grand theft, forgery, and robbery are crimes involving moral turpitude in some states. It is difficult to discern a distinguishing set of principles that the courts apply to determine whether a particular offense involving sexual and family crimes is a CIMT. In some cases, the presence or absence of violence seems to be an important factor. The presence or absence of criminal intent may also be a determining factor. The CIMT determination depends upon state statutes and the controlling case law and must be considered on a case-by-case basis. The presence of fraud primarily determines the presence of moral turpitude in crimes against the authority of the government. Offering a bribe to a government official and offenses relating to counterfeiting are generally crimes involving moral turpitude. Offenses relating to possession of counterfeit securities without intent and contempt of court, however, are not generally considered crimes involving moral turpitude. Under Florida jurisdiction, crimes involving moral turpitude can lead to deportation proceedings. The term moral turpitude has been deemed sufficiently clear in deportation contexts. Crimes involving dishonesty, fraud, embezzlement, and similar offenses are generally considered to involve moral turpitude. For instance, theft has long been recognized as a crime involving moral turpitude, regardless of the sentence imposed or the amount stolen. Federal law stipulates that an alien is subject to deportation if convicted of a crime involving moral turpitude committed within 5 years after entry into the United States, provided the individual is sentenced to confinement for a year or more. The definition of conviction for deportation purposes is determined by federal law, not state law. Therefore, even if Florida law allows for the withholding of adjudication to avoid the consequences of a conviction, this does not necessarily prevent deportation under federal immigration laws. In summary, under Florida jurisdiction, crimes involving moral turpitude such as theft, fraud, and embezzlement can result in deportation if they meet the criteria set forth by federal immigration laws. Tanner Demmery of Demmery Law is a former prosecutor and public defender who has nearly 20 years of jury trial experience. He is an aggressive litigator who is relentless in achieving your goals. If you or someone you know needs help, contact Demmery Law. Contact Tanner Demmery at 954-224-0577 or email tanner@demmerylaw.com. Keep Demmery in your memory.